now as attorneys representing former NFL player Daniel Muir and his wife say that they're being jailed illegally in a child abuse case involving their son. So 14-year-old Bryson was found at his parents' home July 3rd after being missing for 2 weeks. His grandma told police she was worried about his safety after seeing bruises on his face. A relative then reportedly told police that Bryson was being brainwashed and was allegedly assaulted by his dad on a property with ties to a religious organization.
He was so shocked from even being off that land. He's not even familiar with anything outside of that land. And we've talked about those concerns, and she always assured me that the children were safe.
So now, the Muirs are charged with child abuse and obstruction of justice, and they both have been denied any bond. But they're saying that that violates their constitutional rights. So should they be given bond in this case? Let's bring back in our power panel and discuss. Don Milarsek, I'd love to start with you this time, please.
Well, Julie, as you know, we have a fundamental constitutional right under the 8th Amendment to the United States Constitution for bail. Every case is different, and every case has to go through certain factors: the weight of the evidence, the seriousness of the charge, the ability of the accused to flee, perhaps. But I think there could be reasonable conditions of bond that would assure this defendant appearance and the safety of the community. The judge could order things like GPS, house-monitored house arrest, surrender your passport, check in daily with pretrial supervision. So there are a number of conditions of bond here that I think could be imposed by the judge to ensure the safety of the community and ensure that this defendant will show up on court on time.
Right, Don. You're absolutely right. Judges attach conditions every single day. You'll probably have a bond hearing today, as a matter of fact, and ask for certain specifics to be imposed. And one of them could even be no contact, right, with his son. If the issue in question is whether there was an assault or abuse going on, the court could work out something with the child. I want to play a clip for you all from Nathan Vining, who is the attorney representing Mr. Muir. Let's take a listen to what he says.
What we would do is just ask that the public and the media avoid drawing any premature conclusions. We feel that the Muir family, they're being improperly targeted, and ultimately they're going to get their day in court and due process according to law, and we would just appreciate that you just avoid making any of those premature conclusions.
Okay, and he's right. You know, cases are to be tried in the court of law. Franz Borghardt, to you next, please. Your thoughts on whether Daniel Muir and his wife should have bond here?
So for me, it becomes a question of why are we denying? If the judge is denying solely based on flight risk, I think that a higher court may say, no, they are entitled to a bond determination and you need to set a bond. Now, the judge has a wide degree of discretion. In most states, they can set a bond that's humongous. They can set a medium-sized bond. I absolutely agree. Let's put a GPS monitoring device on. Now, another consideration in domestic violence cases is often the need for a cooling off period. Now, we probably don't have that in this case because they are the parents of the kid. But again, that's sometimes a factor. Sometimes cooling off and letting the parties kind of settle. I think ultimately they're going to have a bond set. I would anticipate it being a large bond. These are probably individuals that don't have extensive criminal histories. And I agree that there are measures that can be put in place to ensure their attendance at court proceedings. But for now, they're sitting and waiting. And, you know, maybe a higher court will disagree and say, no, the judge has the discretion to do this.
I like the point you made, Franz, about the cooling off period. That can be a good thing for everybody. And this is just pre-trial. This is just in the time prior to, you know, the first couple of hearing dates. This is where they are. And maybe that's not a bad thing right now for everyone's safety. Kinsey Schofield, last but certainly not least, final thoughts on this case from you, please.
Oh, Miss Julie, I am obsessed with this case. I mean, both Daniel and Kristen are both known members of a religious organization, the one that owns the property that some digital commentators accuse of being almost cult-like. There are several YouTube videos that feature Daniel as shepherd, Pastor Muir, and brother Daniel Muir. And court documents say that during a recorded jail conversation, Daniel said that if the family lived in their homeland, his son would have been put to death for his acts. Perhaps the courts I mean, the courts very much likely know much more than we do. Are they continuing to collect evidence? I don't know. But I think that this is just the beginning of this case.
Kinsey, thank you so much for that backdrop, because this is something that isn't being talked about. You know, when you see headlines, it's just, oh, we've got a former NFL player and his wife, and the child is okay. But, you know, we have this question of whether there was an assault. I mean, when you said death, and he's saying in you know, in the religious culture, that's, I mean, oh my gosh, I get a chill all over my body with that. You know, and maybe that's what prosecutors are going to argue again and again before the judge, to keep denying bond. We'll leave it there for now, but thank you for all of that. Kinsey, we've got to say goodbye to you. Big thank you for all of the insight today. We'll see you soon.